Welcome to study session 4, Grievances and Resolution. What is a grievance? The term grievance refers to a written statement made according to the grievance procedure included in the collective agreement. It deals with any dispute concerning the interpretation, application, administration, or the alleged violation of any clause of the collective agreement. Such a grievance may arise from a violation of the collective bargaining agreement or violations of the law, such as workplace safety regulations. All employees have the contractual right to raise a grievance, and there is a statutory code of practice for handling grievances. Employers cannot legally treat an employee any differently whether he or she has filed a grievance or not. The difference between a grievance and a complaint in the unionized workplace is whether the subject matter relates to the collective bargaining agreement. A serious grievance may lead to a strike action. Grievance is any unreasonable treatment, dissatisfaction, or feeling of injustice in connection with one's employment situation that is brought to the attention of the management and requires action or response under laid down procedures and policies. Complaint, on the other hand, is the act of expressing one's dissatisfaction with a supervisor. It becomes a grievance if the supervisor is unable to settle the problem satisfactorily, and then the employee appeals the case to the next higher level in management, according to the steps in formal grievance procedure. Major causes of grievance. Major causes of grievance: failure to promote from within, inadequate or incorrect equipment, revised wage and salary systems, unexplained or unclear directives, unequal distribution of overtime work, unfair work assignments, favoritism, personality conflicts, unhealthy or unpleasant working conditions, unequal pay for identical work, failure to act promptly on complaints, age discrimination, sex discrimination, and ethnic discrimination. When an employee may not express dissatisfaction, he may have high tolerance limits for frustration. He may feel that a condition may soon change for his or her favor. He may have found that from past experience, it does no good to complain to his or her supervisor. He may feel that others will criticize him or her if he or she complains, while employee grievance handling is formalized. The supervisor may lack the necessary human relation skills to deal effectively with his subordinates. He or she may lack the authority to take the action that is really necessary to properly solve the problem. He or she may know from past experience that it is futile for him or her to try to get higher management to act. Some supervision. Take 2. Some supervisors may suppress the expression of grievances by their subordinates. The employee may feel that his or her immediate supervisor has discriminated against him or her and will not fairly and objectively judge him and the situation. It brings employee problems to the attention of higher management. It serves as a legitimate, official, approved way of appealing grievances to higher management. It reduces the likelihood of arbitrary action by supervisor because the supervisors know that the employees are able to protest such behavior to higher management. What is grievance procedure? The procedure can have 2 or 4 steps. At each step, representatives of the employer. Take 2. At each step, representatives of the union and the employer meet. When a case is settled through a grievance. Take 2. When a case is settled through a grievance, it can serve as a precedent or a model on which the merits of the similar cases will be assessed in the future. Precedents are usually very important because they establish how the union and the employer will interpret the collective agreement from them on. Features of a good grievance procedure. Complaints must be fully described by the person with the grievance. The persons should be given the full details of the allegations against them. The persons against whom the grievance or complaint is made should have the opportunity and be given a reasonable time to put their side take to. Should have the opportunity and be given a reasonable time to put their side of the story before resolution is attempted. Proceedings should be concluded honestly, fairly, and without bias. Proceedings should not be unduly delayed. What is an effective grievance procedure? An effective grievance take-two. An effective grievance procedure should allow the following outcomes: a peaceful method of conflict resolution to reduce industrial action and provide greater stability, quick and effective results, improved communications and working relationships, employee participation and consultation in the workplace, increased productivity and efficiency of the organization, resolution of problems with workplace change programs, better emotional well-being, performance and morale of employees, avoidance of the cost and delays of going to the tribunal, natural justice for employees. Some practical suggestions for settling grievances at lower levels. The lower management staff should be able to listen with an open mind, ask open-ended questions to draw the employee out, control temper and reserve opinion until all facts have been gathered, define the problem clearly in a manner that is agreeable to both parties, consult the union, contract and/or labor policy and the labor relations department if necessary, be consistent, check for a precedent before making decision, consider the effect of the settlement on other departments or employees. If none realizes, this action may serve as precedence. Give clear answers and provide reasons for the decision. Keep a record of the action. Inform the employees of further steps which he or she may take. Grievance settlement for unionized employees. The signing of labor contract does not automatically take care of all possible labor relation problems that will arise during the span of the relationship. Therefore, a grievance procedure provides one means of settling such difficulties. The draft grievance procedure can cover both individual and collective grievances. Stages in such a procedure could be: employee notifies the employer in writing or otherwise as to the substance of the grievance, requests a meeting with the management and states the remedy sought. Discussion is held between employee and representative and first-line manager if the matter is not resolved. Employee and representative confers with senior management if the matter is not resolved. Joint meeting with employer or senior management representative if the matter is not resolved. Mediator is contacted if the matter is not resolved. Arbitrator is contacted. The supervisor's roles. The supervisor must be granted the necessary authority to make at least an initial settlement on his own, must be fully trained in labor policy, contract interpretation and human relations for efficiency, must learn to listen attentively in order to obtain the subordinate's full story as she or he sees it. By the nature of grievances, he or she is in the best position to make a full investigation of the facts of the problem, can collect data and examine records as well as interview union representatives, employee and management staff personnel to compile a full account of the facts and history surrounding a case. When a supervisor is not sure of issues, he or she should refer such to an immediate boss or the Industrial Relations Department, though he should not just be a figurehead. Mediator. When labor and management are deadlocked on a grievance settlement, the matter may also be resolved through a less powerful remedy called mediation. In mediation, an impartial individual or panel hears the issue. Arbitration. Arbitration is a method of dispute resolution used as an alternative to litigation. It is commonly designated in collective agreements between employers and employees as a way to resolve disputes. The parties select a neutral third party, an arbiter, to hold a formal or informal hearing on the disagreement. The arbiter then issues a decision binding on the parties. The federal law governs the practice of arbitration, while the Federal Arbitration Act, by its own terms, is not applicable to employment take-two. While the Federal Arbitration Act, by its own terms, is not applicable to employment contracts, federal courts are increasingly applying the law in labor disputes. Arbitrators are employed in two ways. 1. Permanent arbitrator, the umpire system. The permanent or full-time arbitrators are employed on a salary basis. 2. Ad hoc, employed for a case alone. Below are differences and similarities between arbitrator and mediator. Meaning: arbitrator. An arbitrator is a neutral person chosen to resolve disputes outside the courts. A mediator is usually one who resolves disputes between people, organizations, states, and any other communities. Judgment. An arbitrator's judgment is considered final and binding. A mediator does not deliver a judgment. A mediator facilitates dialogue between the two parties, and it is up to them to come to an agreement. An agreement reached after mediation is not binding. Applicability. An arbitrator gains importance in case of major disputes or when the parties are unreasonable, or when a specific area of expertise is required. A mediator is usually chosen to resolve a minor dispute, or when the parties do not wish to enter the litigation track, or when confidentiality of the issue is required, or when knowledge of the issue is critical. Managing grievances. The managers should adopt the following approach to manage grievance effectively. 1. Quick action. As soon as the grievance arises, it should be identified and resolved. Training must be given to the managers to effectively and timely manage a grievance. This will lower the detrimental effects of grievances on the employees and their performance. 2. Acknowledging grievance. The manager must acknowledge the grievance put forward by the employee as manifestation of true and real feelings of the employees. Acknowledgement of the manager implies that the manager is eager to look into the complaint impartially and without any bias. 3. Gathering facts. The managers should gather appropriate and sufficient facts explaining the grievance nature. A record of such facts must be maintained so that these can be used in later stage of grievance redressal. 4. Examining the causes of grievance. The actual cause of grievance should be identified. Accordingly, remedial actions should be taken to prevent repetition of the grievance. 5. Decisioning. After identifying the causes of grievance, alternative course of actions should be thought of to manage the grievance. The effect of such course of action on the existing and future management policies and procedures should be analyzed, and accordingly, decisions should be taken by the manager. 6. Execution and review. The manager should execute the decision quickly, ignoring the fact that it may or may not hurt the employees concerned. After implementing the decision, a follow-up must be there to ensure that the grievance has been resolved completely and adequately. Study session summary. In this study session, we learned that grievance is a written statement made according to the grievance procedure included in the collective agreement. It deals with any dispute concerning the interpretation, application, administration, or the alleged violation of any clause of the collective agreement. This is the end of study session 4. Thank you.